Hello, everybody. My name is Jordan Walker. I'm an attorney with Seaver Walker Paget Law Firm. It is 2:30, and I have a feeling we're going to run long today. So I don't want to belabor this any further, and we're just going to go ahead and get started. I'm sure people are going to trickle in as we continue. Thanks for joining us today. With that said, we are going to go ahead and get started. So again, my name is Jordan Walker. I'm an attorney with Seaver Walker Paget Law Firm. Our Georgia office is located in Alpharetta, Georgia. There's my contact information if you want to jot it down. We'll also put it at the end of the presentation as well, and you also have it from the letters that we sent. Real quick, just an introduction to who I am, what our firm is, what we're doing, because sometimes there's some confusion. I've spoken with a lot of you already about these letters that we sent out. So I just want to be clear in who we are before we get started. Seaver Walker Paget is a eminent domain only, landowner only law firm. We are not with Southern Gas. We are not with the pipeline. We are not with FERC. We are not with anybody but landowners that are affected by this project. We are strictly eminent domain. This is the only type of law that we practice. We're not only eminent domain, we are landowner only. We have never represented pipelines. We've never represented power lines. We've never represented GDOT or any governments or municipalities in Georgia or across the country. This is the only area of law we do, and we only help landowners. And we'll talk about how eminent domain factors into this pipeline as we sit right now and as it will in the future. But I just want to stress right now, because sometimes there's confusion, we do not work for the pipeline. With that being said, like I said, we are eminent domain only, we are landowner only. And as a consequence, because this is the only type of law that we've done, this is the only type of law that I've ever practiced as an attorney. And because this is the only area of law that we do, we've developed quite a bit of experience with these types of projects, with any type of eminent domain acquisition. But even more recently, specifically utility projects, large interstate gas pipelines, large interstate oil pipelines, large interstate transmission lines. These are becoming more and more frequent in recent years, so they're taking up a large focus of our practice right now. But we have done this across the country. We've done this in Georgia. I am personally licensed in many states, several states, including the state of Georgia. And so we've done this a lot. We've done hundreds of pipeline cases across the country. I've done pipeline cases in Georgia. We've done them in Oregon, Indiana, Iowa, Illinois, Ohio, Kentucky, you name it. We've seen it all. So the reason why I'm saying that again is that we have learned a lot. We've learned a lot about eminent domain. We've learned about how pipelines work. We've learned a lot about this type of situation that you're going to find yourself in here shortly. And so our job today, what my job is today, is to share with you the experience that we've learned, educate you guys on what to expect here as we get into land acquisition with this project specifically, so that you guys are better educated, better prepared when the pipeline comes through and starts contacting you about getting an easement on your property. And just real quick, another question we get a lot is, why did I receive a letter? Why did our firm send you this letter? You received this letter. We monitor projects across the country, and when they are ready to go, when they start to get into land acquisition. So what we have found is that your property was identified in federal documents at the Federal Energy Regulatory Commission, FERC, by Southern Gas, by the pipeline. They identified all the properties that were affected by this project, and your property was in the way of their current path. It was either on the path or very close to it. So we believe that your property is very likely to be affected by this project, by the South System Expansion 4 pipeline. We're just going to call it the SSE4 moving forward because it is a mouthful, and I don't want to take too much time just saying the name of the project. But anyway, your property was identified on public records, public documents before FERC. We researched, we monitored these projects, we saw it, and we sent out the mailing to the based on the documents that were presented to the federal government. So that's how we got your information. That's why we sent the letter. This is all public information. And that is why you received the letter from us, because according to us, according to the information presented to FERC, your property is in the path of this pipeline. And I do want to stress, if there are questions, please save them for the end. We will have a Q&A at the end, and there's a good chance I'll answer your questions in the interim. But if you have them, think them, jot them down, and then we will get to those at the end. So real quick about this project, the South System Expansion 4, the SSE4. As you can see by the map, this is a significant pipeline. It's very long. It's 273 miles of looping. And what looping is when a pipeline decides to run another pipeline adjacent to an existing one. So there's already a pipeline that goes through a large majority of this route, almost to South Carolina to the east and into Mississippi to the west. And so what Southern Gas wants to do is they want to put one right next to it, largely for the length of the existing pipeline. That's called a loop. That's pipeline terminology. All you need to know is that they want to run one parallel to the existing one. And that's going to be relevant as we get into this presentation, and I'll explain how. Because this is a natural gas pipeline, because this is an interstate natural gas pipeline, it is governed by FERC. This is not all pipelines are governed by FERC. If this were an oil pipeline, it would not be governed by FERC. If this were another type of substance that's not natural gas, it would not be governed by FERC. Because it is, though, because it's an interstate natural gas pipeline, it has FERC jurisdiction. And what that means is that before Southern Gas can build this project, they need to go to FERC, which they've already begun that process, and get approval. Okay? Any interstate natural gas pipeline needs federal approval before it can be built. So right now, as we sit, Southern Gas has filed their what's referred to as their pre-filing application with FERC in October of 2024. They filed their actual application this year. So they did their pre-filing, and then they filed their actual application, their actual filing this year. And based on the schedule, they are expecting approval in early 2027. And the reason why I'm talking about this is because with FERC approval comes eminent domain authority. So as we sit right now, the SSE4 does no federal eminent domain authority. They do not have the ability to seize your land as we sit right now. However, when they get that FERC approval, which again, they expect in early 2027, with that approval, and we are assuming that they will get it. I'm not saying they will. For purposes of this presentation, we are going to assume that they're going to get that approval. Generally, when pipelines seek this approval, they do get it. They have a very high percentage of getting their petitions approved by FERC. Not everyone does, but generally they are approved. If, for example, it isn't approved, then they can't build the pipeline. But for purposes of this presentation, we're going to assume that it gets approval. If you are not a fan of this pipeline, if you want to stop this pipeline, if you want to change it, amend it, stop it in its tracks, the time to do that is now before FERC. And you can do that, or you can attempt to do that, I should say, by going onto the FERC website. They have an online docket with e-filing capabilities. You can get on the FERC website. You can file into the docket and say, I'm a landowner and I don't want this thing to be built. You have that ability, and I'm not dissuading anybody from doing that. My goal today is not to diminish or try to say that you shouldn't be able to challenge this pipeline if you want to. By all means, do what you got to do. In our experience, again, these pipelines are often challenged by a lot of different groups, environmental groups, landowner advocacy groups, Farm Bureau, you name it. But generally speaking, they are approved. And that's not, again, to dissuade you, but that's the reality of these pipelines. But regardless, if you aren't a fan of this thing and you want to stop it in its tracks, or you want at the very least your voice to be heard, go onto the FERC website, see if there's any landowner groups in the area that are seeking to stop this project. Join them, make your voice heard if you'd like. If that's your goal, if that's what you want to do. We're not necessarily talking about that today. We're talking about the actual acquisition of your property. But I did want to say that for any of those landowners out there that are interested in doing something like that. So, like I said, if and when they get federal approval for the project, they get eminent domain authority. What is eminent domain? Eminent domain is the power to seize private land and put it to a public use. Now, you might be asking yourself, well, wait, Southern Gas is a private company. How do they have it? How can they get eminent domain authority? And the reality is that even though they are a private utility company, they are not the government. With this FERC authority, they basically step into the shoes of the government, or they act like the government, such that they can acquire your land, whether you like it or not. That is eminent domain. Eminent domain effectively is they can take it. Now, an easier way to look at this is if this were GDOT, for example, the Georgia Department of Transportation, or your local county, or your city, wherever you're located in Georgia. All of these entities have the ability to acquire your land and put it to a public use. The most common exercise, or the most traditional exercise of eminent domain, is for roads. Road projects, highways, interstates, etc. Those all need to be built, of course. And in order to build them, oftentimes they need to acquire quite a bit of land. And landowners can't just say, no, I'm not going to sell my land to the DOT. And so consequently, they can acquire it whether you like it or not. So the DOT can do it, Georgia DOT, cities, municipalities, other government entities. And in the same vein, the pipeline will have this ability to, at some point, assuming they get approval for the project. Again, so even though it's traditionally, for people that do know what eminent domain is, generally they know it based on road projects. It's equivalently the same for utility projects, power lines, pipelines. These are a public use. These have found to have been a public use, even though the people that are acquiring them are not necessarily a governmental entity. So even though they have the ability to take your land, or they will have it with this authority, the landowner is always entitled to what's referred to as just compensation for their land. And this is codified in the Fifth Amendment of the United States, it's codified in the Georgia State Constitution, it's codified in all the states' constitution. You are entitled to just compensation for your land. And what that means is that if necessary, you can go before a trier of fact, whether it's a jury, judge, commission, and present evidence as to what you're entitled to for your property. Meaning the pipeline doesn't get to unilaterally decide what you're entitled to. You don't get to unilaterally decide what you're entitled to. Ultimately, if the parties choose and they can't reach a deal, you eventually can present your evidence again to a tribunal to hear the evidence of what you're entitled to, and then ultimately render a verdict for just compensation for what you're entitled to. So keep that in mind, and we'll talk about this later, why this is relevant. But it's just important to understand you are always entitled to just compensation for your land. So this is the eminent domain process we expect Southern Gas to utilize when they get this eminent domain authority. There will be a pre-condemnation offer. And I talked with some folks who called me, and they talked about whether, and there's the question we asked for registration, whether you received an offer. This is what I'm talking about. An offer of compensation. They have to give you an offer of compensation if they need your property and they don't already have the right to use it. A pre-condemnation offer. This offer will include a offer of money, of course. It'll include a map, and it'll include the easement that they want from you. This is where our firm gets involved. This is why I asked that question. This is why we always ask any of our webinar attendees whether or not they received offers, because that's when our firm gets involved. Once you have an offer, you have a theoretical case that we can potentially help you out with. Until that point, we don't really know. We don't know what they're going to offer. We don't necessarily know what they're going to take, or what they want to take, rather. So you don't necessarily have a case until you get to that point. We expect, I don't know, because of course I don't work for Southern Gas. They don't tell me anything, of course. I would expect that offers are going to start trickling out here in the next several months. That would be my expectation. Again, this is a big project affecting a lot of properties. So if you don't get anything by the summer, ultimately it's up to them. It's their project. They have to come to you with an offer if they need your land and they don't already have the right to use it. So just keep that in mind. You will get an offer, and we'll talk about what that means, what it's going to look like here in a bit. They have to issue it as a precursor to any eminent domain. And then there's, of course, a round of negotiation. Now, it isn't always the same. Each pipeline's different. They don't necessarily have to negotiate that much with you. The law doesn't permit a substantial negotiation, Generally, it's good faith negotiation that's required, but that is a pretty low bar in order for them to meet prior to filing their condemnation lawsuit, if they were to. So they've issued the offer at some point. There's some round of negotiation, although again, they don't need to do much. But eventually, if they can't reach a deal with you, the landowner, and they got their FERC certificate, eventually they will begin filing condemnation lawsuits. I should say condemnation is the same as eminent domain. Condemnation is the process, eminent domain is the power. It's not like condemning properties that are unsafe, unsanitary, run down. That is a different type of condemnation. That is a public safety, public health condemnation. This is just to acquire your property to put to the pipeline's use, just to clarify. So let's say you haven't reached a deal with the pipeline and we're in 2027 or whenever they've got their approval. They need to build it, and they have this right that they've earned from FERC. What'll happen next is they will file a lawsuit in federal court. It's likely to be a federal court lawsuit. I doubt they're going to use state court. They could, but I doubt that they will. So it'll be in the federal court in the district where your property is located, the federal district. And they will file the lawsuit, and then effectively the trial becomes over what you're entitled to. Now, you can still at court say this shouldn't be built. This is not a public use. They didn't follow the law, so on and so forth. You can always make those arguments. You are allowed to make them. I will say that generally those types of arguments are unsuccessful at federal court. The public use one especially. Once they get that FERC certificate, their eminent domain authority, which is confirmed by the federal court, is likely to happen. So at that point, largely, when you get to federal court, when you're down in the condemnation lawsuit, the main issue is largely over just compensation, what you're entitled to. And it is important to note that in federal court, you do not have a guarantee to a jury trial. In state court, you do, but in federal court, you do not have a guarantee to a jury trial, meaning you can ask for one. You can say, I'd like to have this heard before a jury. They could give you a jury trial, but it's unlikely. Generally, they'll probably either hear it themselves, the judge will hear it, they'll appoint a commission to hear it, or they'll appoint a panel of judges to hear it. But ultimately, you are entitled. It isn't up to the pipeline what you're entitled to. It's up to whoever the judge and panels to hear your case. So that's the beginning to end. I do want to say that, this is the eminent domain process from beginning to end from a 10,000-foot view. And the reason why I'm talking about this, of course, is that this is not a traditional negotiation that you're going to go through with Southern Gas because of this authority. It changes the dynamic. It puts a shroud over negotiations. Southern Gas uses eminent domain authority. Pipelines generally use it as a hammer to try to leverage themselves against landowners, try to scare landowners into agreeing to things that they probably shouldn't agree to. So just keep in mind that this is the process, but just because this is the process doesn't mean your case is going to get to this point. A lot of our cases don't reach this point. A lot of our pipeline cases don't reach eminent domain. And even then, when they reach eminent domain, even fewer get to jury trial. Most of our cases, a large majority of our cases, settle at some point prior to condemnation or during condemnation. So I want to stress that. Now, it doesn't matter to us, frankly, where it settles, as long as the deal is what our clients want and what they're entitled to. But that's just the nature of the game, that largely the parties reached agreement at some point prior to condemnation, but that's certainly not a guarantee. So let's talk about what they want from you. Let's talk about, this is before eminent domain. We're going back to the negotiations, the offer that they present to you. What is that offer going to look like? What do they want from you ultimately? What they are going to want from you largely on this project is an easement. An easement is a land conveyance. It's a document that conveys a land rights to somebody else. Okay, it's essentially a deed, but like if you've ever sold your property before, usually when you sell property, you sell the entirety of the property. You sell fee simple title to somebody else. That's what it's referred to as. And that's 100% land ownership in your land. If you've sold your house before, you don't sell it via an easement, you sell it via a deed, some sort of deed. And that just says here, this property is now yours. You own all of it. An easement is effectively a deed, but you're not selling the whole ground. You're only selling the right to do what the easement says, where the easement says, and when the easement permits it. So you're basically saying, oh, an easy example is a driveway easement. Say you have a neighbor that needs to access a public road, but they can only get to it through your land. Oftentimes, you'll sell, if you'd like to, sell a driveway easement to your neighbor, and that driveway easement will basically specify my neighbor has the right through this easement to access this public road through my land. And they have the right to access it through this area, this acreage on my land. And the only thing they're allowed to do is ingress and egress to the public road. They're not allowed to build a fence or do whatever they like on that area. They can only use this land for this specific purpose. So that's effectively what an easement is. But instead of a driveway, they're seeking a pipeline easement. And the pipeline easement is, of course, they want the right to build a pipeline on a certain area of your property. And that is, you are effectively going to be granting them an easement to use that property to build a pipeline and all the uses attendant to building a pipeline and maintaining it, of course. Keep in mind, they are going to seek a perpetual or permanent easement from you. And that is exactly what it sounds like. This easement will be forever. It will be forever on your property. It will be a perpetual right to build and maintain a pipeline on your property. So one of the questions I get a lot, and some variation of this question is, what are they going to be allowed to do on the easement? What am I going to be allowed to do on the easement as the landowner? What am I giving to them? And what am I relinquishing from yourself? And the answer to that question is invariably, it all depends on what the easement says. Okay, that document is going to govern what their rights are on your land forever. They're going to govern what your rights are on that area of your own property forever. Okay, so it's extremely important to ensure that that document is drafted very carefully, very precisely, with consideration, due consideration of what you want to use the property for, while still allowing them to do basically the bare minimum of what they want to do. And that's important. It's incredibly important. It's probably the most important part of this presentation, is that easement needs to be carefully drafted, because what is often told to landowners when right-of-way agents come out and talk to landowners about what the pipeline wants from the landowner, what they tell landowners, and I understand they're having public meetings here in a bit, what those promises that are made, these verbal promises, they don't matter. All that matters is what the easement says. So they'll come out and they'll say, listen, we just want to build a pipeline. We just need this area over here. We're not going to upset the rest of your land. We're going to construct it, properly with due consideration to your land, and they'll restore the land appropriately, and they'll do this and that. Those verbal promises mean nothing. All that matters is what the easement says, because 30 years from now, what the right-of-way agent promised you in your living room doesn't mean anything for what they're going to do on the pipeline at that point. They can't look. You can't say, well, listen, so and so promised that they wouldn't add another pipeline to my property, and here you are 30 years later adding another pipeline to my property. What's that about? Well, they're going to say, I don't know what you're talking about, and it doesn't matter. They'll point to the easement that you signed and say, this easement gives us that right, or this easement gives us the right to run fiber optic cable, or whatever, or this easement permits us broad access to the entirety of your property wherever and whenever they want. So it's imperative, of course, that this document is drafted accordingly, because it's the only document that matters. It's going to be recorded. It'll be part of your property's title. When you sell this property to somebody else, when your kids inherit it, when your grandkids inherit it, whenever it is conveyed to somebody else, this easement's going to be there. And so for their sake, if not your own, this document needs to be gone over with a fine-tooth comb. It needs to be redlined. It needs to be modified. It needs to be edited so that you are protecting not only your rights, but their rights as well. Their being whoever you sell the land to, your kids, your grandkids, whoever takes title to the property. Some pitfalls we've seen on easement documents. I want to stress that because offers aren't really being made yet on this project, as far as we've seen, I haven't seen their easement yet. I haven't seen what they're proposing to landowners. What I have seen is a lot of other easements on other projects from other pipeline companies. And oftentimes we see a lot of the same things across pipeline projects, where a lot of the same issues, a lot of the same clauses show up in these documents that are problematic for landowners. So I'm not saying that Southern Gas is going to come in and present the worst easement ever, but be prepared for a document that you might not like, and that might require a lot of changes. Some issues we have seen across documents: unfettered access. We've seen easements grant access rights to the pipelines, not only on the easement itself, but all four corners of the property. We have seen the no clauses for future damages if they come in down the road and need to perform some maintenance on the easement. There's no clause that requires them to pay money, or maybe there's a clause that says they don't need to pay anything and that's it, or for crop losses, or for anything that they end up damaging. We've seen issues with easements not having proper ground restoration. Especially in agricultural areas, it's important that the soil is segregated, topsoil and subsoil are segregated, and put together in order, not mixed together and then thrown on top. That's something that I have seen firsthand. That's very important to ensure that the ground is restored. We've seen liability easements that shift liability to the landowner for any problems that the pipeline, pipeline problems, any problems on the pipeline. We've seen the liability shift to the landowner. So you are now liable for something that happens on the easement, even though it's not your fault. The right to build more power lines, more pipelines, sell their rights to other entities, solar farms, selling everything. We've seen another big one is the right to add, I just mentioned it, add another pipeline and another pipeline and another pipeline. And I'll say exactly why this, we'll give an example of why this is important, or why it's especially relevant on this project specifically. But these are all clauses we've seen, and this is not the only thing we've seen. Every easement's different, every easement's drafted differently. And just be prepared to take a look at it and see some stuff that you don't like. And a lot of it's going to be written in a lot of legal jargon too. And that's another thing that you might not even know what you're reading. So it might be something might be snuck in there that maybe you don't even understand, or you see it and it makes sense to you, but maybe there's a double or triple negative that allows them to do something that you maybe didn't recognize when you read it. So just keep that in mind. Be skeptical of what is presented to you, and get some assistance from attorneys if you can. So I touched on this a little bit. I'm going to touch on it again, why easements are so important on this project specifically. Now, you'll recall this is a looping project, largely looping, where they're running parallel to existing lines. What that means is that existing lines have existing easements. So they're going to put it right next to a pipeline that's largely across this already there. Now, it might be on your land, it might be on your neighbor's land, but largely this line is going to go right next to one that already exists. And you can see on a diagram right here what we're talking about. There's one right there, there's one right there. This is the new one, this is the old one. And because the old one have existing easements, that means that it's likely that you already have an existing easement on your property. You might already have an existing pipeline on your property that you're aware of. Some people don't. Some people don't know that it's there. Some people have never thought about it. But why this is relevant is that the existing easement is now held by Southern Gas. Whoever it was granted by and whenever it was granted by, in the 80s, 70s, 60s, you name it, Southern Gas holds the right to those easements. So they have the right to this existing easement that exists either on your property or near your property. And that existing easement, there's a decent chance, not a decent chance, there is a chance that it was poorly drafted. We talked about the importance of making sure now that these new easements are drafted accordingly. It's possible that the old easement wasn't drafted very well. And it's unfortunately something we see quite a bit, especially on older easements, documents that are signed by the landowners that held the land years ago. They sign these documents, they're promised a pittance of compensation, but they don't read what they're They don't read what they're signing. They don't know what they're signing. They potentially sign the right of way to the right to the pipeline to do well in excess of what is actually told to them. So it's possible that you have an existing easement on your property. It's possible that that existing easement is poorly drafted. It's possible it blankets the property. It's called a blanket easement, where it not only gives them the right to build pipelines in a certain area, it gives them the right to build pipelines wherever they want without further compensation. Does that allow for another line? Does the existing easement allow for another line? Does it allow for as many lines as they want? Well, what else does it permit? Does it allow them to build another line without paying you anything? Or if they build another line, do they have to pay you something? They're not all cookie cutter. They're not all the same, especially when they're signed at different times by different companies. So it's imperative that you, as a landowner, find out what that says, because ancient easements become modern ones. So the one that may exist on your property from the 30s, 40s, 50s, 60s, whenever, is now a modern one. And they might be using rights within that easement to add this new one. Now, we don't know. Every property is different, and I haven't seen anything. But it's important that you find out what that existing easement says, because that'll give you at least a good understanding of what they're going to seek from you, or whether they're going to use that old easement to sneak in another line through the older easement that they already own. So this is important. It's something that, and I'll just say right now, we'll mention it again at the end. You might be asking, how do I find out this existing easement? How do I even know what it is? Well, all you need to do is call your local county recorder's office or your local deeds office and say, listen, I own this property. You have your tax pin or your address. You can give them your name and tell them exactly what you're looking for. Say, I need to know if there's any pipeline easements or any easements on my property. Can you provide them for me? Now, they might make you come into the office, but generally they're willing to just email you or send you what they have. But give them a call wherever the county is, where your property is. Give them the recorders. That's what they're there for. Give the deeds office or the recorder's office or the clerk's office, and they can direct you to the right department and say, this is what I'm looking for. I'm looking for easements on my property. They might charge you like a couple dollars for copying or to send it, but it's not going to be a significant expense. And then they'll send it to you. It's all record. It's all public record. They'll send it to you, and then you can review it. And if you want me to look at it, I can look at it too, and I'm happy to do that and tell you what it says. But at the very least, look at it, see if it gives them the right to add more pipelines, and then you'll know when they come through and they start making offers, what rights do they already maybe have through this existing easement, if there is even one on your property. Again, I'm not guaranteeing that's the case. The only way to know is for you to do a little bit of research to figure out yourself what it says. Okay, so moving beyond easements to the second most important, or the most important, depending on your priorities, part of your case, that is compensation, money. You are going to be selling your property if your property is affected, you're going to be selling this easement. They're going to make an offer to you. A lot of times these offers are just as bad as the easement. What you need to consider in compensation, what you need to look for and make sure you get compensated for, these are the aspects that need to be considered. You need to look at a proper price per acre. It needs to be a proper price per acre or more than the fair market value for the land that's being acquired. You need to have proper payment for crop or timber damages or any other damages that might exist. Financial, if there's a business on the property that's going to be affected or destroyed, that's important. If there's a house, there's a structure that needs to be paid for. If you're need to be relocated because of it, because they're going through your house, that needs to be considered. All of this needs to be proper, needs to be compensated. You need payment for anticipated soil and ground damages, or a very strong clause or a clause in your easement that agrees them to a strong clause that agrees them requires them rather to remediate the land properly. Proper consideration of all damages: field tile, irrigation, compaction, soil mixing, debris removal, flooding if it occurs or could occur. These need to be considered. They either need to be paid for up front, or there needs to be a strong clause that requires their payment in the future. Residual damage. This is a big one. Residual damage is effectively any impact on the rest of the parcel because of the introduction of this pipeline. So it's not necessarily dealing with the 1 or 2 acres that they need from you in the easement, but how does that acquisition impact the rest of the parcel? You have a 40-acre tract, and let's say they're running through the middle of it. How does that bisection affect all 40 acres? What kind of property impact, value impact, has that entire parcel realized because of the introduction of this pipeline? That is an important component, and this is all in addition to the bonus payments that they may offer, utility might offer. Because it's possible, again, we don't know what they look like. It's possible they could offer a signing bonus, these kind of pittance incentives to get people to sign. These are in addition to that. Ultimately, your argument for compensation will be significantly impacted by whether there's an existing easement on the property. If, for example, residual damages are harder to argue for if there's already a pipeline on the property. Because a lot of the times the residual damage, the introduction of a pipeline to property, the first time, causes the first damage and the largest damage. The second pipeline, it can certainly have damage as well, but for a lot of properties, the biggest chunk of damage has already occurred from the existing pipeline. And when I'm talking about residual damages, this means, I guess, this is, we hear a lot about explosions, pipeline leaks, danger, safety problems with pipelines. These are wrapped up into the residual damage. People generally don't want to live near pipelines. They don't want to have to deal with pipelines. The question is, how much does that pipeline's existence devalue the property itself? And if you already have one on the property, the devaluation isn't quite as severe as if it were the first one that would come onto the property. But regardless, it exists and it needs to be considered. So, and I'm running long, and I apologize if you guys have to get going. This will be recorded, and it will be available on our website. So if you have to get going, it will be available on YouTube, on our website. Just jump back on here later this week. You'll be able to see the rest of it. I apologize for going long. Right-of-way agent. So eventually, a right-of-way agent is going to come to you and make you an offer. Now, again, these are individuals. Their job is to acquire your land. This is their profession. They work all over the country. They work for pipelines here and there, and they come out, and their duty is to convince you that what they're offering you is fair, and that this easement is fair, and the compensation they're offering fair. These are the folks that are making those promises I talked about previously. So keeping in mind the fact that their job and their incentive is to sell you on the idea of you selling them their land, your land, they employ tactics, strategies that they've learned over the course of their career to convince folks to sell them their property. So we've seen, these tactics, like as if most of them are presented as if they are doing you a favor. Now, we've actually seen a little bit of both. Sometimes they're your best friend, and sometimes they're your worst enemy. There's a couple of different, it's kind of the good cop, bad cop strategy that a lot of them employ. They might employ both, where they want to be your friend. Hey, we're looking out for you. Or, hey, you got to do this, or you're going to get nothing, or you're going to go to eminent domain, or all the fear is introduced. So we've seen both strategies. One of those strategies is offering what seemingly more than fair market value for your land. But according to who? Is that according to them? 150% of a terrible offer just makes it a bad offer. So just because if they present it to you as if they're doing you a solid, doing you a favor, it isn't necessarily. I wouldn't take them at their word on that. Bonus payments. Again, these are usually pittance, nominal sums that are offered to landowners to incentivize quick decisions. Quick decisions favor the pipeline. They want you to make a quick one. They want you to negotiate on the spot as soon as they show up in your living room and say, well, just sign it. Here's what we'll do. We'll give you a bonus payment if you sign today. They are going to want to have that living room pitch, and they're going to want to sit there and talk to you and get you to sign something on the spot as soon as they present it. And they'll employ these types of tactics to do it. They'll offer timber and crop damages as if they don't already owe those to you anyway. They destroy your crops, you're entitled to compensation for that. So as if offering it, again, is made to seem like they're giving you a deal when this is something they have to pay you for anyway. Understand that the ability to say no gives the landowner leverage. and leverage is generally equals money. They don't want you, they want to make it seem like you can't say no, that you have to say yes. You have the ability to say no. You have the ability to say, I'm going to think about it and get back to you. You have that ability. The ability to do that gives you leverage in a situation where it might not seem like it with this eminent domain existence. So keep that in mind. Leverage is money, and the ability to say no gives you leverage. Verbal offers. Offers they'll raise it, or it'll lower next week, or we'll raise it if you do this, or all of these things usually done verbally don't mean anything. If they want to offer it to you, make them put it to pen to paper. Verbal promises are not worth the paper they're written on. They love to have verbal conversations because they're off the record, and it's important for you to make sure everything is on the record. Ultimately, if you aren't sure if it's a good deal when they come to you and offer you, all you have to do is ask me, send me an email, shoot me a text, and I will look at it for free. I will look at your offer for free. That is something we do as a matter of course. I will review it, give you my thoughts, and you can decide what you want to do. Okay, so what to do when you receive your offer. This is a kind of I guess, a strategy that you can deploy to make sure you do everything right when they come through. First, insist that the right-of-way agent communicate only via email or text. Anything where there's a writing, anything where there's something, pen to paper has been created. Avoid verbal conversations, avoid phone calls, avoid in-person discussions. Make them send you an email, make them put it all on the record so you have a record of what has transpired and what they are willing to do for you. So when they might reach out and say, hey, we want to give you an offer, they might just show up at your house. In any event, what I would tell them is say, you can send it via email. Or if they call you, say, okay, you can send it via email. And then when they send it via email, or they text it, or they send it in the mail, you can say, thank you, I will review this and get back to you in a week. Now, the reason why I say these words specifically, or recommend these words specifically, is that this gives you enough time, gives you a week to do your due diligence, to decide what you want to do, but you're also not putting them off. But you are giving yourself some breathing room, because if you don't give them a time frame, they are going to bug and hound you. They're going to show up, they're going to call you, they're going to do this, they're going to do that. This gives you at least a little breathing room to decide what you want to do, gather your thoughts, get some professional advice, and go from there. So I tell people, say, thank you for the offer. I will review this, and I'll get back to you in a week. You're not blowing them off, but you're also giving yourself some breathing room. Within that week period, you contact an attorney for a review. You contact me. I'll get back to you within a day, give you my thoughts, again, for free. Then you can decide what you want to do. Avoid in-person discussions and negotiations. I already touched on that. What not to do when you receive an offer. Don't just jump into negotiations. You don't know what you're entitled to yet. You haven't done the due diligence necessary to know what you're entitled to. So don't just jump in and start talking numbers. You can ultimately negotiate on your own if you'd like. That's certainly your right. But at least give yourself some time. Do your due diligence. Prepare a strategy. Get an understanding for what you'd be willing to take. Talk to some people. Talk to an attorney, and then go from there. I don't jump in and start talking value, because it's important to remember that all of these conversations with right-of-way agents are documented. They keep copious notes as soon as they leave you. They say the landowner said they would take this. Landowner said this. They said this. So if they come to you and they offer you $20,000 and you say, well, I'll take 40. And they're like, well, we can't do 40, but we'll be in touch. And then you hire me and I say, well, actually, you should be getting 70 or 80. Problem is that you already told them you'd take 40. And they wrote that down. And that follows you the rest of the case, whether it's at eminent domain or not. They know that you would take 40. And that's, it seems first nature to jump in and just double it. But again, doubling a terrible offer isn't necessarily a good offer. It just makes it a less terrible one. So again, just don't, I advise, again, you always have time to negotiate. Just don't jump into it immediately. Don't go out and get an appraisal. Some people think they need to get an appraisal. They are expensive and not always necessary. Very often they are not. So I would not jump in and get an appraisal. Don't meet in person. Don't take right-of-way agents' promises at face value. An easy guideline to follow is do not assume the utility has your interest at heart. Their interests are building a pipeline for as cheap and quickly as possible. That's what they want to do. So anything they tell you that is not that is not what they want to do. It's their goal is to build this thing cheap and quick. So just go into these discussions with some skepticism, and that'll do you better than assuming that they have your interests. Finally, don't make a rush decision. We kind of touched on that, but also don't ignore it altogether. This is something a lot of landowners don't want to deal with. They don't like that it's happening. I understand that. The last thing you want to do is get this offer, throw it on a stack of papers, and forget about it. Because if eventually, and they're not going to let you forget about it. I will say that again. Right-of-way agents are pesky to some extent. They are going to stick around. They're going to bug you. They're going to call you. They're going to stop by. They're going to do this. They're going to do that. They are going to make their presence felt. That is their job. But at the end of the day, it's not something you want to just ignore altogether, because you never know. You ignore it long enough, you end up in court, and maybe you shouldn't be at court. So just it's not something that, again, it's kind of there. Don't go too quickly, but also don't just put it on the back burner forever. If you follow the procedure I set forth in the last slide, you'll be straight. You'll be good to go. You'll be at least be performing it properly. So here's some frequently asked questions I already touched on, but I want to stress. Some of them I've answered, some I've not. These are common questions we get. Do they have the right to survey your land? Yes, they do. This is under Georgia law. They have the right to do it. I understand that they've been reaching out to folks about surveying already because they already have the right to do it under Georgia law. It's something where I'd rather have my landowners coordinate with the surveyors than not. Because generally, if you don't care, you don't care. That's fine. If you don't care if they survey, that's fine. If you do care, then you can coordinate with them to make sure that they're there when you want them to be there, or maybe you want them to be there when you're not there. It just depends on what your preference is. So it's you can either ignore their survey requests and they're just going to come out and survey whenever they want. A lot of them have already done it based on discussions I've had. But you can also coordinate yourself so that they're there when you want them to be there. And maybe if you have livestock, or if you have dogs, or anything that, or hunting. If you have hunting, that's probably not too relevant now, but eventually that's gonna come. That might be relevant. So just something to consider. They do have the right to do it. That is the law in Georgia. Again, how do I find out if I have an easement on my land, or how do you determine this? Contact your recorder in the county where your property is located. Contact the deeds office. If you don't have a recorder or a deeds office, call the county clerk and ask them what you're looking for, and they will point you to the right direction. Request any easements you have in your property, and they will supply them to you. One question I've gotten a lot, and it's the biggest one: how do I find out what they want, how much land they want, where is it going to go? So I don't know the answer to that question. That answer, of course, is only held by Southern Gas. They are not going to tell me how much land they want from each landowner. All we have are basically the very broad maps that were filed with FERC that show roughly the path of the pipeline. The granular data, how much permanent easement they want from you, how much temporary easement they want from you, how much workspace they want from you. You're not going to know that until they approach you. Now, I understand they're having public meetings here across the state. Actually, it might be going on right now in some counties. You can go and ask and see if they have those maps. I wouldn't guarantee that you're going to get that information. It's unlikely that you will. It's even less likely to just contact Southern Gas and say, hey, what do you guys want? Where do you want to go? They are not forthcoming with this information. They will be forthcoming with the information when they need something from you, when they want to acquire their easement. They will when they come to you, they will tell you if they don't, you need to make them tell you where it's going, give them the map of where it's going to go. It should have the acreage they want in each type of easement they want. That is when you're going to find out for sure. Unfortunately, this information is proprietary. It is impossible to find. Trust me, we would look for it and know if it existed online somewhere. But ultimately, you're very unlikely to know until they come to you and approach you with an offer. But if you do have an existing gas pipeline easement on your property that we talked about, it's very likely to guess where it's going to be, and that is going to be right next to it. Very likely, I should say. If you have survey flags on your property for the pipeline, if they've come out and surveyed the property, that will be helpful in telling you where it's going to be on the ground, because the survey flags will generally outline the easement area that they want. So that's something that might assist you in knowing exactly where it's going to be. Ultimately, again, you're not going to know the footage. You could theoretically walk the flags if you wanted to and get a rough estimate of the area, but the documents they present to you will show where it's going. Then another question is, what if I'm never home? What if you're not, don't live there? Ultimately, they have to give you an offer. It doesn't matter that you're never home. They'll send you letters. They'll send you certified letters. They will make their presence known. They'll find you, and they will send you what they want, because this is their job ultimately, is to contact landowners and make offers for properties. Another one, what if it goes through a building? What if it goes through your house? What if it goes through a barn structure? This. They are allowed to go through buildings. They're allowed to go through homes. They're allowed to go through sheds, you name it. Just because you built on it isn't going to stop them from wanting to go through that if they need to go through it. Now, that doesn't, of course, that means, excuse me, of course, that means you're entitled to compensation for the destruction of that building, unless the existing easement says you don't get any. But again, that's going to be parcel by parcel, easement by easement. Ultimately, there is no requirement ultimately that they need to go a certain distance from houses, that they can't go through houses. They can go effectively wherever FERC permits them to go. Now, you're always, of course, are entitled to compensation for wherever they go, unless the pre-existing easement is not great. But the point of this question is ultimately, because a lot of times say, well, how can they build it 10 feet from my house? How can they build it through my living room? How are they allowed to do this? And the reality is that they can go wherever. They can go through commercial operations if they'd like, and I'm sure they will on this project. There's nothing stopping them, I should say, from going through houses, going very close to houses. But it's up to you to ensure that you get properly paid for whatever they are doing. Okay, and this is my last slide before we're going to open it up to questions in my final notes. I do want to talk a little bit about our firm. If you are interested in hiring an attorney, we are here for you. And I understand that a lot of people don't want to pay for attorneys. I get that. Luckily, the way we work, it allows you to hire us without having to come out of pocket. We work on a contingency fee. Meaning we only get paid if we get you more than what is offered by the pipeline. An easy example is the one I have on the slide right here. Say they come to you and offer you $10,000. You come to me and say, Jordan, can you get me more money? Can you help us out? And I say, I think we can help you out. And we help you out and we get you $50,000. In that scenario, we would have added $40,000 to the case. We get a third of the $40,000. You end up with the rest. In this case, in this example, it'd be almost 4 times the original offer. Let's get another example. Let's say you hire us, and this also, I should say, includes easement negotiations as well. Our representation is 2-track. We represent and negotiate money, and that's how we get paid. And we represent and negotiate easement language. So we'll change the easement, and we get paid for our work based on how much more money we get. So it's a 2-track representation. We do both. The reason why we do contingency fees, of course, this allows landowners to hire us without coming out of pocket. It allows peace of mind to landowners to understand that what we're doing is for their benefit, because in this scenario, it's also for our benefit. We have the same goals, you can trust that, whether you trust me or not, you can trust that I probably like making money. And this arrangement allows for that trust to exist, because again, we are partners in this scenario based on this type of contingency fee agreement. Beyond that, if you want to just hire us on a billable rate, an hourly rate, and pay us a retainer, so an upfront payment with an hourly billing charge. we can do that as well. That's something we can talk about on an individual case-by-case basis. But most of our folks like the contingency fee model. So this is my final slide. And my closing thoughts, and then we'll open up questions. If you want to start asking questions, you can put them in the Q&A or put them in the chat, and then I will get to them once I finish this slide. So moving forward, next steps. As soon as you receive an offer, you should hire an attorney. Until that point, begin devising a plan, vetting attorney option, considering your strategy of attack, how you're going to approach this. Get the easement, get the existing easement. If it exists on your property, that will put you ahead of the curve. It's a simple call to the recorder's office. You might already know whether or not you have one. That'll put you ahead of the curve, like I said. See if you have an existing easement, because that'll play a big portion in your negotiations and your leverage. Identify your goals to present to the attorney once you get that offer. You can always go to the public meetings if you like. Those public meetings that are put on by Southern Gas. I wouldn't go into there expecting to get a ton of helpful information because they are largely dog and pony shows, as we've found. So keep that in mind. Strength in numbers. If you have a group of landowners that are all affected, the power of a group is immeasurable. It gives leverage to the group while everybody gets their individualized case. We anticipate representing quite a few folks on this project. You'll be part of a group, theoretically, whether you know anybody or not that's affected. They'll be our group. But ultimately, you have your own individual case with your own individual concerns. It's not a class action where somebody else decides your settlement. You decide your own settlement and what you want. But being part of a group, if you have one, can be very powerful. You and your neighbors get together and are represented by one attorney. If I go to Southern Gas and say, hey, I represent 10 landowners, they're still going to give me some deference because of that. But if I go to them and say, hey, I represent 100 landowners, that kind of changes the calculus for them. So something to keep in mind. The more the merrier, so to speak. So if you do have a group, that's great. Ultimately, and now we'll open up for questions. If you have offers, I don't think anybody does, but if you do, go ahead and send it in for a free review. You can text it to that number. You can email it to that email address. You can fax it to that fax number right there. Woo! All right, I said a lot. So now we're going to open up to questions. I'm sure there are some. Feel free to ask them. First question, can we get a copy of this webinar from Joseph? Joseph, yes, you can. This is going to be available on our website eventually once we get the recording done. If you want to, you should get a link to it after the fact as registering for this. But ultimately, it will be available. Actually, it'll be available through the registration always. So if you want to access it, you already have access to it already. You can also access it on our website too. We're going to put it on our website as well, available for reviewing. Another question, what if the existing easement is with Georgia Power, not the gas company? Well, it depends on if Georgia Power, that easement allows, it depends on if that easement at Georgia Power allows the building of gas pipelines, and B, has been sold to, or at least has been subleased or subrented to Southern Gas. Ultimately, it depends on what that existing easement is with Georgia Power. This is kind of the question for everything. What does the existing easement say? What does it grant? Just because it was to Georgia Power originally, that doesn't mean that Georgia Power didn't sublease some rights within that easement to Southern Gas. But also, it's still, they can't just because you have a power line easement with Georgia Power, for example, it's got to specifically allow for the construction of gas pipelines in order for Southern Gas to be able to build the gas pipeline under that easement. So ultimately, it depends on what that existing easement says. Can you fence the ends of the easement? You can do whatever the easement allows you to do. If you're talking about putting like a temporary fence over the easement, crossing it, or a permanent fence, generally that is permitted. But it might also, you need an easement that would basically allow you to do that. It says that would state that you are allowed to do that. And also that if they come in and knock it down, in the future for maintenance concerns that they either have to put it back up or they have to pay you to put it back up. So again, it depends on what the easement says. Generally, you can build over these easements unless it's like a house, driveway, like concrete driveways, asphalt driveways. Permanent large structures are not going to be allowed to be built on the easement. That's something they're never going to agree to. Fences, depends on the type of fence, depends on what you're talking about. Generally, they're okay with it, but again, it depends on the easement. Would I review oh, somebody just wanted to thank me for offering this. You're very welcome. I'm glad to help. Happy to help anybody who finds himself in this situation. Would I review existing easement? Yes. If you have an existing easement, I will take a look at it. Just send it to me and I will give you my thoughts. Can you get compensated for minerals in the ground? Well, that is a great question. Depends on if you have your mineral rights, and B, it depends on if they are commercially viable. Basically, generally, if it would come with the value of the property on the open market. You know, if you were to sell your land and it would get paid, you maybe get paid more because there are certain minerals in the ground. Then yes, it's compensable. If you just suspect that there's some quantity of minerals in the ground that may or not be commercially mineable, it's probably, and it doesn't really contribute to the value of the property, then you can ask for it, but it's not, it needs to be something, because we deal with cases a lot of times with active mining operations, active gravel, active coal, these types of properties that have these active operations on it. In those situations, yes, 100% compensable. If you have mineral rights that you've separated from, that you own, that are being sold on the open market for a certain amount of money that you can't access anymore, that has value. You can get paid for that. If you just suspect that there's something down there, some coal maybe, but it's not commercially accessible and it doesn't have any commercial value, then generally it's in a court sense, in front of a jury or in front of a tribunal commission, it's going to be difficult to make an argument for more compensation based on that. It needs to have a value on the market. What happens if you have a large creek near the part of land they want? Will that be damaged? Well, you need to make sure that the easement is drafted accordingly, such that if it does affect that creek, that it's either properly restored or that they pay you for it. There are a lot of waterways that are going to be crossed by this. That's fairly common. The Army Corps of Engineers is supposed to evaluate all these water crossings, depending on how substantial they are, such that there aren't any issues with that. Ultimately, crossing creeks for pipelines is not an uncommon thing. But you need to make sure that however it crosses it, however big it is, that it doesn't result in flooding on your property, or doesn't result in that creek backing up and flooding elsewhere. So yeah, that's what you need to. Sorry, I was looking at another question. You need, again, it's one of those things that you need to consider depending on how they're crossing it and what they're doing. You mentioned possible FERC approval in early 2027, but then that we may get offers in the coming weeks. Why would they make offers without approval? Because there's a lot of landowners. It's fairly common for pipeline companies, transmission companies, any really large project, utility project, to begin the land acquisition process prior to final approval. That happens pretty much all the time. Usually offers go out around the time filing is made at FERC. So it's fairly common that they're willing to bet, basically, that they're going to get approval. They're willing to invest in a certain amount of land acquisition now, betting on the eventual approval. So it's fairly common. In fact, it happens pretty much with all projects we deal with. If they waited until approval to start getting offers, or to start making offers rather, it would delay the construction of the pipeline, months, if not another year, because they need to get the rights wrapped up. So they like to get ahead of it, start making offers now, secure the easements now, so that when the approval is granted, they can get shovels in the ground as soon as possible. Every day they aren't building this pipeline is money that they're losing, and it is about money, unfortunately, for them. and by not moving gas through these pipelines. So that's why they do it now, and it's how it is with pretty much every large scale project. Wetlands. Okay, so another question: how do they handle wetlands? Will they destroy them or restore them? It depends on what what that's part of the FERC analysis. Again, they go through a wetlands and water body crossings evaluation at FERC. The Army Corps of Engineers does it, and they do an evaluation of how they're going to cross those or what they need to do to cross the wetlands. So it will depend ultimately on what their plan is that they presented to FERC. We don't get super involved in the FERC process. We know that it exists and we sort of monitor the docket, but we don't really get into the fight or the nitty gritty of how they will handle, for example, wetlands, environmental remediation, those types of things, architectural or sorry, excuse me, archaeological issues. Those are generally handled by FERC. They're supposed to put forth a plan for how they plan to cross those areas, those sensitive areas that FERC will ultimately consider in their consideration of the application. So if you are curious about that, I would go to the FERC docket, and they are so part of the FERC docket is creating what's called an environmental impact statement. So all pipelines need to do a preliminary and then final environmental impact statement, basically evaluating how they are going to handle a wide variety of environmental concerns, wetlands being one of them. And they are, I believe in this one, I believe they've begun their environmental assessment, but it's certainly not finalized. It's not finalized usually until right before approval. That's a big portion of the FERC docket is about the environmental impact statement and how it impacts, wetlands, how it impacts crossings of water, et cetera. So that'll be part of the FERC process. And so I don't have the answer to that right now. We're so early in the process. Other questions? You're very welcome. Thanks for asking them. You're welcome as well. I appreciate the compliments. I'm happy to help you guys out. If you guys want to, if you're feeling particularly generous, go over to our Google page or our Google business page. It's Seaver Walker Paget in Alpharetta, Georgia. And if you could give us a positive review, that'd be great. I'd appreciate it. You don't have to. It'd be nice though. um, you're welcome. Okay. Any other questions while you guys have me? And if you think of something later, you can shoot me an email. You don't need to feel pressed to think of something now. But if you do think of something, just shoot me an email. Email is probably best. It's probably the easiest and quickest. Where am I located? So I alternate between our headquarters office in Indianapolis and our Atlanta office in Alpharetta. But I'm also licensed in Missouri, Illinois, Texas. I forget all the states at this point. No, but in Georgia, of course, as well. Most of my work is in Georgia, but our Georgia office is in Alpharetta. What if it's in a flood zone? If it's in a flood zone, well, then it needs to be considered the potential impact on that, how that affects the property and what kind of flood zone. Is it a 100-year floodplain? Is it, a 10-year floodplain? Ultimately, that will also be part of the federal environmental impact statement that I touched on previously. These sensitive areas, these flood-prone areas, and they're aware of that. They understand that flooding is a big deal for pipeline construction. It's something that they're going to consider. And if it affects your floodplain such that it affects your value, then you need to get paid for it, or you need to ensure that it's constructed appropriately to protect your property. Am I licensed in Alabama? I am not specifically licensed in Alabama. However, if you are in Alabama or if you're in Mississippi, we can potentially work with you on a temporary basis, on a temporary practice permission. So feel free to reach out to me on that individually. It's generally states have temporary practice permits depending on their ethics rules that allow unlicensed attorneys in those states to help out landowners. So we can absolutely talk about that if you're interested. You're welcome. Okay. Well, if there are no more questions, it doesn't look like there are. I'm going to go ahead and wrap this up. Thank you so much for your attention this afternoon. I'm sorry we went so long. I feel like we had to, though. You guys have been great. You've had some great questions. And, I wish everybody good luck, whether you work with us or not, moving forward on this case. And, hopefully when they come through, we can help you out and give you some assistance. But other than that, thank you again for stopping by, and feel free to reach out with any questions that you guys might have.